right, Mr. Brandt, you have reserved 5 minutes for rebuttal, and we'll open with 15 minutes. If you would like to come up and begin, you may do so.
May it please the Court, Tom Brandt for the individual defendants, appellants George Camp, Jana Campbell, Helen Landers, Kenneth Marriott, Colby Perdue, Terry Robinson, Vi Wells, and Scotty York. Referees can't call plays, and they can't veto the plays called by others. No court has jurisdiction or authority to erase Rule 12. That is essentially what has happened in this case. Defense counsel called a play, and that play was a motion to dismiss, and it was overruled and vetoed by the district court. No court has that authority to take that option away. Can't erase it, can't veto it, and cannot, importantly, cannot ignore the merits of that motion. This court has said repeatedly that the district court has to engage the motion, and it's no excuse to say, well, you can proceed through discovery and go to summary judgment, or perhaps later you can ask for leave to file that same motion again. And it is not correct, as the district court has noted in its October 8th order, that somehow that motion is still pending. It is not. It was denied flatly, and it's denied with the phrase without prejudice, which is meaningless, because to deny a motion and then say later you might be able to re-urge it, but you have to ask leave and you have to have good cause to urge that in a 12C motion, is to deny it flatly. And it's to rob the individual defendants of their procedural protections under qualified immunity.
Counsel, I noted that after the judge, in part of his standard, I believe he calls it his standard qualified immunity scheduling order, instructed you to answer the complaint and include in the answer your qualified immunity defense, and that you did so, and then you filed this interlocutory appeal. I'm not asking you to tell us what was going on in your reasons for doing so. I'm just trying to discern whether that in some way should enter into whether or not we would think this interlocutory appeal that we have jurisdiction over it.
Well, I will tell you, Your Honor, I don't think it has any bearing on this appeal. I was very concerned because I was alarmed that, number one, this had happened. It was shocking to me. I've many, many times had judges say, I'm going to let them replead and your motion is moot. That happened to me in Harris v. Balch Springs, and I didn't appeal that. That has happened repeatedly. But I've never had a judge say, not refer to my motion, but say, if there are any motions out there pending, I'm going to deny them. And then say, you've got 14 days to file an answer for 8 individual defendants. A 75-page complaint, 8 individual defendants, that's 8 individual answers to that 75-page haystack pleadings, which by the plaintiff's own admission is not in chronological order. I'm supposed to answer that, and my worry was I do not want to be in default. Number 1 rule is do not default. So I did that, and I had 14 days to do that. I had to get busy and get that done, and then I knew I had 30 days to appeal, but I also had to weigh my options about appeal. This area of qualified immunity, as you all well know, is quite complex. And what I wanted to mention to the court was how important this particular procedural device is in cases such as this, and other cases as well. But the Supreme Court and this court has repeatedly said that qualified immunity must be determined at the earliest possible stage of the litigation. And it has also said that motions to dismiss based on qualified immunity are appropriate. The motion to dismiss is, in our system we go from complaint to judgment. And we go through a filtering process, much like we go from complaint to judgment, we go from lake water to drinking water. Well, you don't have the first filter be shocked with chlorine. What you do is you say, you weed out all the big sticks and fish, And then you get down to the drinking water after a series of processes. That's what we have here. The motion to dismiss is a legal review, and it's very straightforward. Unfortunately for the district court, and I have a great deal of respect for Judge Godbee. I've been in front of him many years, tried cases in front of him, but he got it wrong respectfully. Because what he did was he said, I don't like motions to dismiss. Well, as a defense attorney representing individuals who are entitled to qualified immunity, I like them because they can pare down the case through a legal review where you say, all right, is this plausible? Well, you've got to have granular plausibility. And in a certain sense, you also...
Is that on the record that Judge Godbee said, I don't like motions to dismiss?
No.
Then why did you say it?
Because that's what I take from the two orders. The first one is, we're not going to go... Any motions to dismiss are going to be denied. In my standard, this was not an order designed for my case. He said in his October order that I had made a frontal attack on his standard order. Well, again, I have respect for Judge Godbee, but that's wrong. His standard order is wrong.
Counsel, we see a lot of qualified immunity cases, a lot.
Yes.
And I've never seen a scheduling order. I've never seen anything like what happened in this case. And I'm curious, in your research, is there another district court in the Fifth Circuit that handles QI questions this way?
I don't know the exact... I can't tell you a certain judge who does it that way, but I will tell you this, that I've been fighting this fight for many years, and there is a tendency of district courts to not want to engage in the motions to dismiss. And that's why when I say Judge Barksdale, he doesn't like it, I'm not trying to cast aspersions on him personally. I'm just saying this is...
You can spare all of this about you like the judge, you're not casting aspersions, etc. Just argue your case.
I have seen this happen time and again, and it is something that is... That's why this case is important, because it's not simply this particular group of defendants. It is all defendants in Judge Godbee's court, and I think this is a pattern that has happened in other courts as well.
Counsel, let me follow up on what Judge Oldham just asked. Is there not a somewhat regular occurrence to allow limited discovery on qualified immunity issues once the motion's been filed? And I realize that you're arguing that this is an extraordinary order that is well beyond that, but don't district courts typically allow limited discovery on qualified immunity?
That is typical, yes.
While the motion's pending?
Well, not while the motion to dismiss is pending, no. That's atypical. What is typical, there's two versions. One is, and I've had both, where I say, you know what, in good faith, I cannot claim that this complaint does not state a plausible claim. In those cases, I just file an answer. And then, in Judge Godbee's colleague, Judge Ada Brown, I have a case just like that right now. So I answered. I didn't file a motion to dismiss, and she put us on a fast track for summary judgment and discovery. I have no quarrel with that. But when you file a motion to dismiss and you're saying, I think these 8 individuals, I don't think if you go through the granular analysis of the 75-page complaint, I think you're going to judge, I think you're going to distill out some of these people that there's just not enough there. And then you're going to be better equipped, because what Judge Godbee's order was telling us to do was to work together to figure out what the issues were for limited discovery. And what the law requires him to do is look through it and tell us what he believes are the issues. And he has the Rule 7a reply under Sheltia that he had. That's fine. Where the two mistakes were to dismiss without discussion at all, without engaging in the motion to dismiss. And secondly, to say that Sheltia required me to raise a qualified immunity defense only in my answer. That's clearly wrong. Iqbal itself was a motion to dismiss, went before the U.S. Supreme Court, and the cases are legion about that. So my problem is that a qualified immunity defense made in a motion to dismiss cannot be ignored. It's not enough to just say, well, you'll be fine, deal with it on summary judgment. You're talking about, in my perspective as a practitioner, I'm saying, how in the world can I keep my clients protected in this circumstance from this broad-reaching discovery? And to say that they can be deposed as witnesses in this case is an end run around the protections that they're afforded under qualified immunity. Because think about it. These individuals, these 8 individuals, to get Hunt County, the entity, held liable, at least one, if not all, but at least one of them has to be deliberately indifferent. So you have to go through the analysis, and they have to be found to be deliberately indifferent. And then the next step for the county is to say, well, was that a policy, custom, or practice that caused that person to be deliberately indifferent? And so what happens is, he said, well, you can depose every one of those 8 individuals because they're fact witnesses. And then, the county has no qualified immunity defense. Very correct. The qualified immunity does not apply to Hunt County. But to allow that discovery is clearly an exception that swallows the rule. It is an end run around the rule that says, unless and until the district court has determined that these are plausible pleadings against individual defendants, that you have both plausibly pled a claim and you've plausibly pled enough facts to overcome their entitlement to qualified immunity, they have pled that the conduct of these individuals was such that no one would think that that was legal. So it was clearly established that their conduct was not entitled to qualified immunity. He would have to make that ruling first and say, he would have at least a preliminary ruling to say that I think enough has been pled here to state a claim, number one, and number two, to state that clearly established law has been violated by these individuals. Neither one of those steps were taken here. Instead, I was put to the unusual and difficult task of saying, okay, what do I do with this order now? And that's why it was my judgment call to protect my client so that I don't go, I'm not accused of being a default after all. And I think my decision was correct because I was still fending off motions at the district court level. And as your honors know, just on last week, you granted my motion, at least in a temporary sense, to be stayed from discovery. Those are the battles that I was fighting a two-front war after I'd already noticed an appeal. And I lost at the district court level, and thankfully, your honors ruled in my favor on that motion. I think it's important to know that because I do not and will not default ever for my clients. I might as well just quit practicing law if I do. But this is a very, very unusual situation, but it's unfortunately the rule, the standard rule, at least in this particular district court, and I'm afraid because I practice in this area among these district courts that oftentimes these type of orders become standardized with others, particularly if I had not appealed and then it becomes almost a cultural habit, as it were, and say, Tom, you're the first person to be bothered about this. And I'm saying, well, I'm sorry, but my reading of Iqbal and my reading of Shaltia are very different than Judge Godbee's, so I take this appeal. And I noticed I have very limited time left, but I do want to mention the Longoria case. I know you're familiar, you've read the cases, the Longoria case and the Randall versus Lockwood case. And what we're asking this court to do is to reverse the district court's denial of my motion to dismiss and vacate the scheduling order and then allow me to, and remand it with instructions to allow me to refile my motion to dismiss, because that motion to dismiss was not fully briefed in terms of I filed it, and then shortly thereafter get the order saying it's gone. So we'd like to start fresh, press reset, and allow us to go forward on our qualified immunity assertions.
Why do you need to refile your motion to dismiss? You're appealing from the dismissal without prejudice of that motion. If we vacate that ruling, the motion is ready to go.
Well, that could be, that certainly is your option.
All right, thank you.
All right, thank you, Mr. Brandt. You have 5 minutes reserved for rebuttal. We'll hear from Mr. Thomas now.
Thank you, may it please the court. Bruce Thomas on behalf of the appellee plaintiff below. When Carswell, mother of Gary Lynch and also the administrator of his estate. We'd very much like to proceed in our case. But even more than that, we would very much like to know what are the rules of the road? How are we supposed to proceed in these cases? And in that respect, maybe this appeal is a good thing to develop some rules of the road, because we face this discovery dispute all the time, whether there should be a stay, what the extent of the stay is. To a large extent, this dispute is a dispute between the defendants and the district court that we're caught in the middle of. We didn't write the scheduling order. It's not a scheduling order we would have drafted. We have seen a couple of similar examples that we mentioned in our brief. Judge Cummings said something similar, where he struck the motions to dismiss and said, you got to file an answer first because I have to have an affirmative defense before I consider qualified immunity. And Judge Pittman, I think, uses something similar. I haven't seen a scheduling order to the extent of Judge Godbee's, but I've seen similar approaches. We would just as soon respond to a motion to dismiss.
Counsel, do you think, suppose I was a district judge, let's take this out of qualified immunity for a minute, and I saw an antitrust case, and I have a scheduling order. It's called Scheduling Order - Antitrust. And it says, this is an antitrust case. All motions to dismiss are denied. It'll proceed to discovery. Do you think I could enter that scheduling order in every antitrust case?
I think you could. In your discretion, as a district judge, you could decide how best to control your docket in an individual case, and if the parties had a problem with it, to bring to your attention why that should not be the usual case, why the order should be modified for that case.
Twombly was an antitrust case.
Twombly was an antitrust case.
And the Supreme Court specifically said you can't do that.
Well, Twombly, I don't recall the Supreme Court saying specifically that there was a scheduling order like that, but if you say there was,
well,
I haven't reviewed it.
It specifically said the reason for Rule 12b-6 is to prevent cases going to discovery until the plaintiff has met his or her burden to show sufficiency of the allegations.
Well, yes, but I don't think it said you necessarily have to decide the issue with a 12b-6 motion. I think it says you have to decide the issue before you can subject the defendants to party discovery. I don't recall a statement either by this court or Twombly where they specifically said you have to decide it that way.
Without Rule 12b-6, how else would you decide it?
Well, you can decide it on a 12b-C motion. You can decide it on summary judgment on the pleadings, which is how it was done in the example I gave you in Judge Cummings' court. It's how Judge Godbee wanted to proceed here. As I said.
What do you think the distinction would be between summary judgment without discovery and Rule 12b-6?
Summary judgment on the pleadings I don't think is functionally different than 12b-6. Except from Judge Godbee's, Judge Cummings' perspective, they said you got to plead an affirmative defense first. I think that's an overly strict reading of asserting an affirmative defense in pleadings myself. But their control, whether I like the order, I think is a completely different question from whether they have the right to proceed in their court in that fashion. And I think this court addressed those issues in the Wooten versus Roach, Mesa versus Livingston, and addressed these first two issues that the defendants are raising. to go back to Judge Barksdale's point, I think the answer did affect the first two issues. I think they did take 12B off the table when they decided to go ahead and answer and not complain about the scheduling order to the district court. If the motion to dismiss was denied and they went ahead and answered, 12B says after you answer, you can't file the 12B motion. So they voluntarily did that without complaint and then made the decision to appeal. They could have appealed beforehand and could have taken up the dispute with the district court and objected, and they didn't do it. So I think they themselves took 12B off the table.
It's quite a position to have to roll the dice as to between succeeding on appeal and being in default. That's sort of pushing all in.
I disagree. I don't think they were in any danger of being in default. All they had to do to stay the proceedings was to appeal within the 2 weeks before the answer was due, or ask for an extension. They had gotten 2 extensions previously to respond. They wouldn't have had any problem with getting another extension, I'm sure, if they had felt that they needed it.
But of course, your argument is that there's no jurisdiction over this appeal as it stands today.
That is our argument.
I don't take it, I mean, part of your argument, I suppose, it hinges on the fact that the answer was filed, but part of it seems to be, the way I read your brief, the red brief that is that somehow the judge didn't deny the QI motion. I'm sorry, the motion to dismiss raising QI. And I'm confused by that, since the sentence in paragraph 2 literally says the motion to dismiss is denied.
Without prejudice, yes. That's what we say that the court decided in Wooten versus Roach, that a dismissal without prejudice doesn't decide anything, doesn't present any issue for review in the Court of Appeals. That's what happened in Wooten versus Roach.
So some denials without prejudice don't, but some do. And so the question is, in a qualified immunity circumstance, if the motion to dismiss is denied and you order a defendant to proceed to discovery, then you have denied the motion to dismiss for qualified immunity purposes. It gives rise to interlocutory appellate jurisdiction for that collateral order, and we review those every day in this court. We have 2 QI cases on the docket literally this morning.
I would disagree with the description that the judge ordered them to proceed with discovery. The district courts have viewed the question of whether you proceed with a discovery, at least most district courts, whether you proceed with discovery against non-QI defendants as a separate issue as to whether you would proceed with discovery for the purpose of determining whether qualified immunity exists. For those purposes, the order flatly stays discovery. It doesn't allow discovery to proceed on the issue of whether qualified immunity exists. It does allow discovery to proceed against co-parties, as most district courts have allowed. Since the Harris decision in 2014 and the Saines decision the year after that, I'm sure Judge Garvey didn't think his order was anything unusual, given that most district courts have allowed non-QI discovery to proceed against co-defendants.
And here
we got another, I'm sorry.
I didn't mean to interrupt.
I was just going to say, we got another order on that just Friday, allowing us to proceed against the city of Pasadena out of the Southern District on non-QI co-party discovery, citing Harris and Saines, distinguishing Iqbal and saying it did no violence to this court's Zapata 2-step decision because it concerned a separate issue of third-party discovery or co-party non-qualified immunity discovery. And so the defendants are correct that there are a number of, is a rather routine order coming out of the district courts, but I don't think it's a revolt of this court's or precedent. I think this court hasn't addressed Harris. It hasn't addressed Saines. It hasn't given us the rules of the road. The only circuit court I know that has is the Sixth Circuit, and in its recent In re Flint water case. And there it cited Harris with approval, and in a situation similar to this, it allowed discovery, fact discovery on the co-party co-party non-qualified immunity to proceed.
What sort of discovery would you get against the 8 individual defendants that would be relevant to the Monell claim against Hunt County?
And that's an important question because said discovery could proceed in their capacity as fact witnesses, but it would have to be relevant. It would have to be relevant, and that's what the Sixth Circuit looked at. It said we're not going to assume that that discovery questions are going to be a subterfuge to defeat qualified immunity. We want the district court to consider it in that context.
And let's talk about how it would actually work. So we're in a depot room. We have a 7-hour notice depot against a nurse. When the questions start veering off of whether there was a policy sufficient to trigger Monell, what is the recourse of the nurse and the defense lawyer to avoid the that doesn't tread on the immunity to suit that qualified immunity is supposed to protect? I don't understand. I just don't understand how this would work practically.
I think one way it could work in that context for those type of depositions, of course, I mean, the issue is do you get any discovery, but for those depositions of parties, I think you'd probably have to have a special master there to make a ruling on it.
In the room?
During the course of the depositions in order to carefully guide that deposition. The sort of questions you could ask, though, of parties that would be relevant to Monell is, were you following county policy in what you did? What was the policy? What supervisors are aware of this policy? How was this policy implemented?
But why would you need the nurse? If the question is whether there's a policy, wouldn't you need the policymaker?
Well, you would be asking the nurse whether she followed policy. The policymaker, I mean, sure, you need the policymaker. The policymaker is not necessarily going to be forthcoming to you. The nurse might have different testimony than the policymaker and tell you that she thought very much she was acting as policy, and that her supervisor knew that this was how everybody acted, and his supervisor knew that, despite the fact that those policymakers are saying, oh, no, we didn't know that. I mean, that's the purpose of discovery, to find that out. Also to ask, were other people doing this? Were there other instances of this occurring? To go to the pattern issue, to prove up the Monell pattern. That is where most Monell cases falter, on the pattern issue. So it seems to me very fair game discovery to ask whether there are other people doing this. And of course, depositions. But more important to us, we didn't ask to go for a discovery order to go take their depositions. But we do want to proceed with discovery on the, as soon as we can, on the Monell issues.
Isn't the practical application, though, of paragraph 2 regarding discovery that the defendants who are asserting qualified immunity, the individuals, would probably have to sit for a deposition twice, once on the Monell issue, should you choose to pursue that, which I would think that would be part of your strategy with regard to the policy issue, and then have to come back later if they're not successful on their QI motion, they'd have to come back and sit for a deposition again. Aren't we parsing out the case into 2 sections at this point and having these defendants sit for a deposition 2 occasions as opposed to just once?
Maybe that would happen, and maybe it wouldn't happen. Begin with the court.
Well, I understand it's in theory, but we're trying to appreciate the order that's been entered, and it's been offered as a fairly standard scheduling order, but isn't that the net impact of it?
Not necessarily, because there are several ways that wouldn't happen. One, the court does have discretion, and I'm not arguing that it doesn't. The court does have discretion to limit discovery. The question is, does the judge have to enter a stay of non-QI discovery? The court certainly has discretion, and in this instance, we brought the issue to a head on the depositions because we wanted an order. We wanted to know, are we supposed to go ahead with depositions? And we're fully expecting them to file a motion for protective order so we get a ruling on that. And the Judge Cobby certainly has discretion to say, no, don't proceed with those depositions in this instance.
And were you proposing?
And we've said we're not going to proceed unless we get an order that says we can proceed. The other thing that could happen is the parties, if such a deposition was taken, parties could determine that, could agree that the deposition could be used in a case.
When you proposed the
Otherwise,
deposition?
If not, it could be a second one.
When you proposed the depositions, did you propose to have a special master in the room to police the line between the two claims?
No. No.
But that's your position today?
I'm saying that could be one solution. That could be one solution. If the court's inclined to allow us to proceed with depositions. The more important issue to us is not necessarily the defendant's depositions, but the ability to take discovery to preserve witness testimony in the case. At some point, the policy of qualified immunity, as important as it is, runs into also the due process rights of the plaintiff. Defendant's not the only one with due process rights. We have a right to present our case, to get it ready for trial, and indefinite stays cause us to lose evidence so that we are unable to present our best case, particularly in this COVID environment. If we have an unlimited stay in place, we have a number of witnesses out there. Many of these were co-detainees with Mr. Lynch, and saw what happened, and they are scattering to the four winds. And they are out there in a COVID environment, and we don't have any ability to preserve their testimony. And so at some point, unlimited stays closes the courthouse door to the plaintiff because we can't prepare our case to present our best case and ultimately get to a jury to have our claim determined. So I would ask the court to consider those issues. That's not cost-free when you put in a stay of discovery and protect the defendants from discovery. It has costs to the plaintiffs too. The district court suggested, well, if I don't allow qualified immunity as to co-parties, that's just going to cause the plaintiffs to go out and file two separate suits. Not only are we going to have two depositions, but now we're going to have two separate suits. They'll sue the governmental defendants in one suit and the individual defendants in another suit. If that's going to be the rule of the road, then we can adapt to that. I don't know that that's a terribly good solution. I think that's just going to bounce the issue to whether the cases should be consolidated in that case. But you could have a situation, particularly in a state like Mississippi that has a 3-year statute of limitations, where the plaintiff makes the decision they're just going to sue the county or the governmental entity initially, and immediately commence discovery, take all the fact witness depositions that they want, and make a decision at a later time as to who, if any, any defendants who might assert qualified immunity they might want to sue. You probably wouldn't be able to do that in Louisiana because Louisiana only has a 1-year statute of limitations. So there's a difference in standards that would be imposed in different states that would limit the ability to do that. But those are additional problems that I would ask the court to consider in giving us the rules of the road, that there are unintended consequences and additional costs. This court, in its own jurisprudence, has not taken the position that discovery is stayed as to co-parties, and that's the case that we cite for that. Well, actually, the defendants first cited, but we cited also, is Zantis versus Seal. Zantis versus Seal, and it says pretty much the opposite. Well, it does say the exact opposite of what they're saying with respect to the issue of whether Iqbal requires a stay of all co-party discovery until all the plaintiffs have had all the defendants have had their qualified immunity defense determined. In that case, there were 9 defendants, and 4 had the issue decided on summary judgment against them. 5 had yet to have the issue decided. All 9 appealed a discovery order. The 4 with summary judgment against them appealed that as well. This court affirmed those summary judgments. And then as to those defendants, the court said, plaintiff is entitled to all appropriate discovery as to the summary judgment defendants, even discovery that does not relate to the qualified immunity defense. So this court did not say, no, you can't have any discovery. It gave a blessing to continuing complete discovery against the 4 summary judgment defendants who were basically not qualified immunity defendants anymore because the issue had been decided against them.
Thank you, Mr. Thomas. Mr. Brandt, you have reserved 5 minutes.
Paragraph 2 of Judge Godbee's order turns qualified immunity on its head. And just as you had indicated in your questions, we would be in 2 depositions. And the first deposition would be a nightmare. In all my years of practice, I've only had 1 deposition in which a master was appointed to that deposition. That was because it was a pro se, crazy person. And we had to have some order that was preserved there. But what has been invited here is for us to go into a room with no rules and to be fighting over everything. Every question would be contested. We would have, it is a nightmare. So that paragraph 2 also, by the way, did say I must file an answer by 14 days. I didn't have, I mean, in that sense, almost it was as if I was being ordered directly to answer, and certainly I could have filed a motion to extend the time, I suppose. You know, there's many ways to second guess that, but I vehemently reject the notion that by filing an answer I've somehow waived any right I had because I was put in a terrible position for that. And I would point out that the district court's order has specifically violated Iqbal and is also hasn't carried through with the careful procedure that this court has announced in Bakke and that where there's supposed to be engagement with the substance of the motion to dismiss. And then if there's a determination by the district court that there is enough pled to state a claim and enough pled to state a violation of clearly established law, then you can move to discovery on limited issues if that's what the district court needs. If the district court says, I can't answer those 2 questions without knowing the answer in, you know, say, hey, George Camp, I need to know some more information about what he did, or Helen Landers, I need to know specifically a little more detail about this before I can rule on your motion to dismiss. Then you've got a very, very narrowly tailored, focused deposition that may be happening in which I can be in that room and it not be a chaotic environment in which we're arguing over everything. That's the advantage of the system that we have because, as I mentioned, the filtering system, we have this legal filtering on the motion to dismiss 12b-6. So it violates Iqbal, and properly, Judge Oldham, you asked about Twombly. It was an antitrust case, and it rejected the old Conley versus Gibson standard, which basically invigorated the motion to dismiss practice. Because before that, under the Conley standard, it was any plausible state of, you know, it wasn't plausibility, it was any set of facts. And that standard was retired by the Supreme Court in the Twombly case. And then, out of the antitrust context, it was applied to the qualified immunity in Iqbal in the context of a motion to dismiss. So it is absolutely clear. Iqbal could not have been clearer. The Supreme Court could not have been clearer in what it was saying there. Motions to dismiss, qualified immunity are okay. You can file them. They should be looked at carefully, and no discovery should proceed unless and until it is determined by the district court that sufficient facts have been pled to, number one, state a claim, and that claim and those conduct at issue in this case was clearly established. That it was clearly established that that particular conduct of each one of those 8 people, each one of those 8 defendants, was violative violative of clearly established law. Unless and until that analysis is made, no discovery, cabined or otherwise, direct quote from Iqbal, no discovery, cabined or otherwise, is permitted. Now, what Iqbal didn't address is what the Fifth Circuit has addressed it in its careful procedure, saying once we get past that Iqbal motion to dismiss phase, then we look into, okay, do I as a district judge need some more information here to feel comfortable about ruling on this motion to dismiss? If so, then I'm going to laser focus in on this one defendant. You haven't done enough on these 7, but this one maybe, let me look at it, I need a little bit more information, okay. Then you've followed, and I have difficulty admitting that that careful procedure is correct at all, but it is certainly the Fifth Circuit's ruling in this court. And I would ask, Your Honor, that we reverse, vacate, and remand. Thank you.
Thank you, counsel. We have your arguments. The matter will be considered submitted.